Well, hello there, everyone, and welcome. Welcome to this live stream session. My name is Lior Samfiru. You see my name there. I am the employment lawyer, and I'm here on this session to talk to you about employment law. I'm one of the founding partners of Samfiru Tumarkin LLP. We are the largest employment law firm in this country. We operate in Ontario, in Alberta, in British Columbia. So if you're in one of those places, if you have a question about employment law, if you want to better understand your legal rights and what to do in a workplace situation, well, you've come to the right place. This is the session for you. We talk about employment law here, and this is a live session. You have an opportunity to ask questions, to ask me questions, to get me to read it and answer you, tell you what to do, tell you what your rights are, and give you the help that you need. So take advantage of that. Right now, I am live here. Questions are already coming. I'm going to start answering them in a moment. Now, before I even start answering them, I want to give you some additional information. So we're here live for the next 30 minutes. But if you want to connect with me and my team off social media, off Facebook, off LinkedIn, etc., easy to do. You just go to employmentlawyer.ca. You see that address below me. Of course, it's employmentlawyer.ca. And when you go there, phone numbers are there. Email addresses is there. It's all there to reach out. You can fill out a form if you prefer. You can learn more about employment law there. It's kind of your one-stop shop for anything and everything employment law. So that's employmentlawyer.ca. So remember that. Tell others about it. Such a good tool to connect and get that help that you need. But right now, for the next 30 minutes, you're watching me. I'm Lior Samfiru, the employment lawyer, and I want to make sure that when you're turning off your computer today or closing your browser, you would have gotten answers to the questions that you have. Maybe you lost your job and you want to know what to do about it and what you're owed. Maybe your boss is mistreating you, bullying, harassing. What to do? What is the law? Well, ask the question. Maybe your job has changed, your hours, your responsibilities, you're being relocated. You name it. If it has to do with your legal rights in the workplace, you're watching the right session. I'm Lior Samfiru with Samfiru Tumarkin LLP, live here for you at your service. So let's start answering some questions right now. All right, let's see. First question from Ganga Deep. My WIB benefits were denied. Still being denied by LifeWorks. So Gangadeep, I don't know what WIB benefits are. Not something I've ever heard of before. Maybe it's a typo there. So perhaps you want to re-ask the question. I'll be happy to read it and answer it. Okay, there's no benefits that I'm aware of called WIB. All right, next question comes from Ocean Breeze. What a beautiful name. I wish I was in the ocean right now feeling the breeze. Ocean Breeze on YouTube. I've heard of employees who, over a short time period, had multiple days off because of medical reasons, with provided doctor's notes. Their employer had someone else confirming that they went to the doctors. How does an employee, there you go. How does an employee deal with this? So, well, in terms of going to the doctor, all you really need is a doctor's note. If you have a doctor's note, your employer can't do anything. You don't actually have to go to the doctor. Maybe you've spoken with your doctor on the phone. Maybe you did an online session with the doctor. If you have a doctor's note saying you need to be off work, that's all you need. There's nothing you need to worry about then vis-a-vis your employer. They can't question you. They can't get confirmation that you drove to the doctor's office. None of that's relevant. What's relevant is that you have a doctor's note saying you cannot work. If you have that doctor's note, you can be off, whether it's a day, a week, a month, a year, maybe it's a day here, a day there. You have to, or you have the ability to do whatever it is that your doctor says you need to do. That note is powerful. It's so powerful. Oftentimes employees and employers, frankly, don't realize how powerful that doctor's note is. So get that doctor's note. If your employer does anything to you contrary to that doctor's note, call me right away, okay? And to reach out to me, of course, my team, employmentlawyer.ca is the way to do it. Again, employmentlawyer.ca. All right, great question. Thank you for that, Ocean Breeze. Now, next question from Juanita. I've heard you guys mention a wrongful dismissal, but what exactly does that mean and how do you claim for that? So a wrongful dismissal is simply a situation where you've been let go from your job without the compensation that you're owed. Now, here's the thing. Over 90% of people, when they're let go, are actually wrongfully dismissed. The reason for that, over 90% of the people that are let go are not offered proper compensation, proper severance. So if you've been offered 2 months severance and you're owed more than 2 months, you're owed 5, 7, 10 months, you've been wrongfully dismissed. So wrongful dismissal generally has nothing to do with the reason. And that's because an employer can let you go pretty much for any reason as long as they pay you proper severance. So you may think, well, they let me go for no good reason, and you're probably right. Or you may say, they told me it's a restructuring, but they lied about it, and you're probably right. But that in itself is not a wrongful dismissal. A wrongful dismissal is a matter of severance. But if you lost your job, chances are you've been wrongfully dismissed. Chances are you're owed a lot more than what the company is paying you or offering you. And how do we deal with that? Easy. You call us, we review the situation. If you're owed more, we deal with your employer to get you what you're owed, to get you more. So this is a good time, Juanita, for you and for anyone else. If you want to know how much you're owed, okay, you lost your job, you're worried about losing your job, how much do they owe me? How much do they have to pay me? Here's what you do. You got your smartphone, your tablet, your desktop, and you go to pocketemploymentlawyer.ca. You'll see that address on the screen right now. It's pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator tool. That's it. All you do is you use that severance calculator tool. It's going to take you about 30 seconds. It's completely free. It's completely anonymous. It's incredibly easy to use. You answer 3 questions and it's going to tell you how much severance you are owed. And then you can compare that with what you've been offered. Now, you can also reach out to me if you want directly from the severance calculator. It's easy, it's free, it's anonymous. Over 2 million people have used it so far. Again, pocketemploymentlawyer.ca. Juanita, hopefully that explains wrongful dismissal. If you need more information, if you have a follow-up question, please let me know what that is. All right, let's see. Next question comes from Seven on YouTube. My next step was supposed to be a mediation to settle with myself and lawyers and the defendant, but now it seems they might want it to go to trial. Can they do this? Well, let's take a step back. I'm assuming you're involved in a legal dispute with a company, maybe your former employer. Can they go to trial? Well, I think you know the answer, right? I mean, that's why we have trials. 98% of matters settled way before trial. Now, I don't know enough about your matter to say, but the question that you've been asking should go to your lawyer. If you have a lawyer, what are the chances of settling? How much can I expect to resolve it for? What happens if we don't resolve it at the mediation? Those are questions you need to pose to your lawyer, because I don't know anything about your matter. I can tell you, again, we've been doing this for many years. I personally have been practicing law for over 20 years. I've done hundreds of mediations, over 90% of mediation settle cases, okay? But of course, there's always the 1 or 2% cases that go to trial. Very unlikely, and if you have a good lawyer, you shouldn't have to go to trial. For those joining, you see how easy it is. I'm Lior Samfiru, the employment lawyer, and what I've been doing and what I'm going to continue doing is answer your questions. How do you do that? How do you get me to answer them? You have a box on the screen in front of you. Type in your question, hit enter, and I'll see that question. It's going to pop up on my screen. I'll read it, I'll answer it, and you walk away with the information that you need. So please continue asking questions. Don't wait till the end of the session. So many times people wait till the end and they don't get to ask the question. The time runs out. You have time now. Bring them on. I'll get to it, I promise. All right, let's see. Next question from Michael. Michael is joining us today from YouTube. I just moved to Edmonton. I transferred with my company. I have been with my company for 34 years. After 1 month of work in Edmonton, I was terminated without cause, and the payment is a third of the calculation on your website. Can I claim unemployment if I'm being paid out severance? So first of all, in terms of severance, after 34 years, you're going to be owed 2 years severance. I can almost guarantee that, right? 2 years severance, 24 months. So if you've been offered a third of that, that's what, 8 months. That's ridiculous. That's absurd, right? You're owed 24 months and they've offered you 8 months. Ridiculous. So what you need to do today, not tomorrow, not after the weekend, you need to reach out to me and my team. I said how to do that. I'll give it to you again. employmentlawyer.ca. Again, Michael, employmentlawyer.ca. Phone number is there, email address there, all the contact information is there, so you can help, so I can get to work to help you. It's not difficult to resolve. We'll get this resolved. We'll get you paid your full amount. Now, in terms of EI, well, you need to apply to EI, but EI is only going to kick in after the severance runs out. But that's fine. You're going to be paid for 2 years. If you're still not working, EI is going to kick in. For now, we need to make sure we get you the severance that you're owed. 8 months after 34 years? No way. Ridiculous. The good news is we can get this resolved quickly. Michael, again, chat to me as soon as possible, employmentlawyer.ca. Great questions today, guys. Let's see. Tanya has the next question. Let's see. Tanya asks, management started trying to create problems because of reasonable accommodation. What steps should be taken? Well, first of all, is you want to document everything. So if you're, whatever the company is doing to you, you have to document, write it down, send someone an email confirming what they said, what they did, what happened. You don't want it to be your word against someone else's. Make sure you have a doctor's note if you need accommodation, okay? A clear doctor's note saying, this is what Tanya needs. She needs A, B, and C, okay? Have that doctor's note. If the company won't accommodate you, then we need to talk. That could be a human rights violation. That could be a constructive dismissal. It's illegal. But if they say or do anything to you, maybe they're now making your life miserable because you want accommodation. They're not going to admit that, right? Later on, they're not going to say, yeah, we did it. We have to prove it. So in writing, always create that written record and then call me. Once you have that written record, call me and we can deal with that. I can either get the company off your back, or if you want, I can get you out of there with compensation. So Tanya, that's what you do here. Very good question. Hopefully I've given you some guidance. If you have a follow-up question, please ask it right now. You see how easy it is? That's a very important question that Tanya just asked. She's not being treated properly. The company is not meeting its legal obligation. So by all means, please, please, please do the same as Tanya. Call or ask the question right now, or if, of course, you can call at the office as well later on. But right now, I am live here for you. Still got plenty of time. So ask your question. Make sure that you get answers like Tanya, like Michael, etc. I'm going to continue answering questions right now. As you're listening to my answer, type in your question as well. From Marilyn D'Souza on YouTube is our next question. I am currently working for a company for 33 years. As of January, my husband has been suffering from dementia and I was given permission to work from home. I've been trying to get help to assist my husband so I can go back to work. Unfortunately, sometimes I cannot get a PSW to assist. I have no other help to assist me. Can my company force me back to work given my family situation? So if your husband needs that care, then under human rights legislation, they have to provide that accommodation. They do. Yeah. So make sure it's in writing. You tell them that you're the care provider, you're the only care provider, and you're the only one that can help. If they refuse to accommodate, if they say, too bad, we don't care, come back to work, call me. Generally speaking, a letter from me is going to immediately fix it. They'll read it and they say, okay, fine, our mistake, we misunderstood. Of course, you can work from home. So that's what you do, Marilyn, if you need some help. But make sure it's all in writing. Make sure they understand exactly why you need to be home with your husband. Great question, Marilyn, and good luck to you and your husband. I hope things work out. All right, next question from Flowers. Good name, nice name on YouTube. Flowers asks, is it illegal for a provincial government to mandate COVID vaccines for their employees, otherwise face termination? The reality is that the government is able to do that, okay? An employer that's not government can't necessarily do that. Well, if they let someone go, then they would have to pay them. They have to compensate them. It is different for the government. The government is able to do that. Okay. Michael, who was let go after 34 years, says he already has an appointment with my team at noon. Well, that's great, Michael. You've done the right thing. If you're talking to someone on my team, you're in fantastic hands. We've got your back. We'll get you your matter resolved. So I'm glad you've done that. Thank you. So maybe you can show up here in a week or two, give us an update so everyone can see that you got your matter got resolved, that you got the severance that you're owed. Okay, let's see. Continuing. Good questions today. Tigers Rangers from Facebook asks, how much can you get from the Human Rights Tribunal for being let go for a human rights matter, i.e. they fire you due to being in hospital for mental health reasons? So, obviously you cannot be let go for having a disability. If you have a serious mental issue, health issue, and because of that you are let go, that could absolutely be a human rights violation. Now, keep in mind, the fact that you were let go in itself is not a human rights violation. I'm going to give you an example. If they shut down the department and they let everyone go in the department, including you who was in the hospital, that itself is not a human rights violation because it would have nothing to do with your disability. But if part of the reason why they let you go is because you were sick or because you're in the hospital, well, no, that's a human rights violation, and they really can't do that. So depending on how they treated you and the reason, from a human rights standpoint, the awards generally are not huge. It could be anywhere from $20,000 to $50,000. But keep in mind, you're also owed severance, and the severance that you're owed if you're sick is going to be more than if you were healthy. It's going to take you longer to find another job if you're still struggling with your health. So you're going to get much more severance than you would have if you were perfectly healthy. So you need to deal with that as well. The best thing to do not file a human rights complaint. Okay, there's better ways to get human rights damages. Call myself, my team, and let us assess how to best get you the compensation that you're owed quickly. Going through the human rights process can be a black hole. You can be stuck there for years and years and years. There's better ways to do that. So Tigers Ranger, to reach out to me and my team, you see that address on the screen below me, employmentlawyer.ca. Again, employmentlawyer.ca to do that. And we'll be happy to help you. Absolutely, employmentlawyer.ca. My gosh, you guys are sending me some amazing questions today. I love it. I'm happy to see that. I want to answer as many as possible. Still got time. Ask them. I'm going to continue answering right now. For those that are just joining us, welcome. My name is Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta, and I'm here live answering your employment law question, your workplace rights questions. So if you have a question, if you've always wondered about something, can your employer do something? No need to wonder anymore. You can ask right now, and you'll get your answer. All right, continuing. Lucia on YouTube. She says, good afternoon. I'm Lucia, or Yuzia. I apologize if I mispronounced. My employer fired me, but pay only $2,986. I've not accepted that. Working for 9 years, 60-year-old cleaning job. So if you've been working there for 9 years, you're a cleaner, 60 years old, you're probably owed around 10, 11, maybe even 12 months of severance, somewhere between 10 to 12 months of severance. So I don't know how much you were earning, but obviously you were earning a lot more than $3,000 a year. So that offer is obviously ridiculous. You're owed a lot more than that, Yuchia. So, and up to a year's pay. And by the way, this situation that Yuchia finds herself in is not unique. As I said before, 90%, think how much that is. 90% of people, when they're let go, whatever they're paid or offered is a lot less than what they're actually owed. So the good news, Yuchia, is we can get this resolved, and we can get it resolved quickly. What you do now is you contact myself and my team. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca. You see that on the screen. You'll see the phone numbers there, the email address is there. You can fill out a form if you prefer, and we'll call you. So by all means, do that. We'll help you. You're owed a lot more than $3,000. All right, let's see here. Michael Keller says, his position was supervisor. And the reality is, Michael, that regardless of your position, after 34 years, you're going to get the maximum severance that someone gets, and that's 2 years' pay. So the maximum generally is 2 years. So whether you're a supervisor or working minimum wage or or something else completely, you're going to get the maximum after 34 years, and that maximum, most cases, is 24 months. All right, lots of questions. All right, let's see. Next question from NoMFS on Reddit. I was recently let go via text message for making too many mistakes after a year of work. My employer is refusing to give me my final paycheck. Can they do that? Can I get a wrongful dismissal? What are my legal options? First of all, they have to pay your last check, no matter what you did. Frankly, even if you stole from them, I'm not saying you did, of course, but even if then, they have to pay you for your time work. They don't get, even if you owe them money, they don't get to deduct what you owe them from what they owe you. They have to pay you. Okay, it doesn't work that way. So right off the bat, they're doing something illegal. Now, beyond that, wrongful dismissal means that there's severance owed. They actually may owe you severance even if you've made mistakes. The only way a company can let someone go without severance is if they have what we call just cause. To have just cause, you would have had to do something terrible. And making a few mistakes, if that's all you did, is not going to be enough for it to be just cause. So chances are you're owed severance. And even after a year, I think you said you've been there for a year, you could be owed several months of severance. It could be 3, 4, 5 months of severance. So definitely you need to call me. We need to get you your last paycheck. That's easy. They'll pay that very quickly. But also severance. It could be several months pay that they owe you. Okay, to connect with me and my team, everyone sees that address right now below on the screen, employmentlawyer.ca. Again, employmentlawyer.ca. Okay, get me, Lior Samfiru, the employment lawyer. You, the ones with the questions, ask them. Sam on YouTube has our next question. The company just laid off a group of people due to restructuring. They are now shifting a lot of responsibility to the remaining staff. Can they legally force us to take on multiple positions duties? So it comes down to how will this impact you? So if this means that by giving you other duties, you're going to have to work a lot longer hours, or you're going to have to stay a lot later or work weekends to catch up, they can't do that. If it's just one of those situations where now you're going to have to reshuffle things, but it's not going to impact things too much, then they can do that. So the real question is not, can they do something? It's a question of how is this going to impact you? Now, if it's going to have a significant impact on you, it's going to mean you have to work a lot longer hours. It means you're going to have to stay later, etc. Well, that could be what we call a constructive dismissal. What that means is that by changing the terms of employment in such a big way, you can look at this as a termination. You can look at this as if they let you go and demand and require them to pay you your severance. So that's how this works, Sam. If it's going to impact you significantly, you have that constructive dismissal option. But before you do anything about it, you have to call us. We need to properly assess it, and then we can talk about how we pursue it and how do we get you the compensation that you're owed. So that's the answer there, Sam. Hopefully that makes sense. Feel free to ask a follow-up question if you have it. Happy to answer that as well. All right, question from Katie J on YouTube is our next question. Can reduced work hours be a form of accommodation for a disability? Absolutely. If your doctor says that you can't work 40 hours a week, you can only work 15 hours a week now, that's the accommodation that you need. Absolutely, your employer has to provide that accommodation. So it's a very common type of accommodation. But remember, it all starts with your doctor. It's not enough for you to say, hey, I need to work less hours for medical reasons. That's a good start, but you need a doctor's note to say that. If a doctor's note says for the next 6 months, 12 months, forever, you need to work reduced hours, then the onus moves to the company to make that happen. If they don't, you know what to do. You contact me. Yuzia has a follow-up question. She says, my employer that paid severance of $2,986 said that the company is small and they don't pay much. Is that correct? No, it's not correct. The size of the company is irrelevant. Whether you work for a company with 1 employee or 100,000 employees, the severance is not going to matter. It's not going to change. Your severance is based on your age, the type of job that you have, and the length of your employment. So I think you had said you've been there for 9 years. As I said, you're owed 10 to 12 months of severance. The size of the company is not relevant. It's not going to change how much you are owed. So as I said, you now need to contact us as soon as possible, today, okay? And you do that, you'd see that through employmentlawyer.ca. I'll give it to you one more time, and you see that on the screen right here, employmentlawyer.ca. All right, let's see if we can get a couple more questions in. you can maybe squeeze in one last minute question, guys. So do that. YouTube question from Martin. I was just terminated on May 11th after 8+ years. I was handed a printed sheet stating that it was effective as of May 11th. I'm being given 8 weeks of pay with no explanation of a reason. Company has new owners and are moving to new location. I told them I'm not happy having to drive 94 kilometers each way on the 401 Monday to Friday. What are my rights? Well, your rights are to get a lot more severance than 8 weeks. So if you've been there for 8 years, you're probably owed, again, I don't know what your job is and your age, but it could be as much as a year's pay. It's not going to be less than 8 months pay, likely, but not 8 weeks. That's nonsense. That's ridiculous. So yes, they have to pay you severance. They have to pay your full severance. It could be as much as a year's pay. So for you and for anyone else, I'm going to give you that reminder one more time. Go to our severance calculator. Pocketemploymentlawyer.ca you'll find is the way to find our severance calculator and find out how much you're owed. Find out the real amount. You see that address right here, look at that. Pocketemploymentlawyer.ca. Use it. It's free. It's anonymous. Everyone should use it. Everyone should know exactly what the law says they are owed if they lose their job. All right. Next question here. Sorry, Tanya says, did you miss the call from our company? Then call us back. Tracy says, I have been a victim of bullying by a former staff member. My employer informed me of this after he was terminated. This has caused me much mental distress. What, if any, recourse might I have? So I'm not sure what you mean that your employer informed you that you were a victim of bullying. Are you saying that you didn't know that you were a victim of bullying? So I'm a bit confused about that question. Generally speaking, if you're a victim of bullying, the company has to investigate it and deal with it and make the problem go away. So if they are aware of the problem and if they've dealt with it properly, then they've done what they're supposed to. All right, I think last question for the day. So Tanya, sorry, before I do that, Tanya, can you get constructive dismissal if union does not help? No. And if you're part of a union, unfortunately, there's no point to call us because only the union is allowed to help you. So everything that I talk about on this session, everything I talk about on any session only applies to non-union employees. That's why we call this employment law. Unionized situation is labor law. Very, very different. So none of this applies. Nothing that you hear me say applies to unionized employees. All right, last question today from Chris on Reddit. Can your employer force you to not wear a mask at work? I have a respiratory condition and would like the added safety of wearing a mask, but my employer has said that we're not allowed. All you need to do is a doctor's note saying that. If you have a doctor's note saying that you need to wear a mask, they have to allow you to wear it, okay? It's as simple as that. If you don't have a doctor's note, they can say, no, we just don't like how that looks. It's silly, but if you have a doctor's note, they have to get that doctor's note, and then everything will be fine. If it's not fine, if they still refuse after you get a doctor's note, you call me and see how fast I can get that changed, okay? So thank you for that question. All right, those are the questions, the time for the questions we have today. Thank you so much for joining me. Lots of questions, lots of fantastic questions. I'm glad that I've had this opportunity to be here again. I'm Lior Samfiru, the employment lawyer. 10 a.m. Pacific time. Next Tuesday, May the 23rd, we're doing another session focusing on disability with one of my partners, Martin Willemese. So if you have questions about that, join us. For now, if you want to connect with me and my team, employmentlawyer.ca is the way to do that. I'll be back, of course, next week. We'll be doing more of these sessions, other lawyers as well, so stay tuned for that. Thank you very much, everyone. And again, don't forget employmentlawyer.ca. I'm Lior Samfiru. Take care.